Hello, international lawyers and law students. If you are here to learn legal English, you're in the right place. I'm Catherine. I'm the director of Cambridge Law Studio, which is a specialist school of English only for lawyers. I was one of the founders of the test of legal English skills. Apologies if you're doing that. I know it's hard. Don't forget to download our free vocabulary PDF to go with this lesson. I wrote it, not ChatGPT, so you can rely on it. It's pretty good if I say so myself. Welcome to our quick legal vocabulary class. Encumbrance. The legal English word encumbrance is very important for any lawyer who works in commercial law or real estate law. Like many legal words, the dictionary definition is not very clear. The best way to explain the word encumbrance is with a practical example. Now, dictionary definitions of legal English words are usually, can I say bullshit, or is that awful for a formal teacher to say? But they really are. I hate legal dictionaries because they're too academic and they don't help you. So I'll be more polite and I'll say garbage. And the best way to explain everything is with a practical example. So let's go. Here is our example situation. Please imagine just for a moment that you are the owner of a bookstore in your country, and I am a publisher of books in the UK. You have placed an order with me for the purchase of 2,000 books, and I will issue an invoice to you for the payment of £30,000. It's quite a lot. Actually, I really am a publisher of books, so you can imagine this one. At that price, each book is £15. I don't know what that is in US dollars, probably about $18 each for 2,000 books. At that, you're going to get 30,000 British pounds. Now, when you're paying me that much money, you don't want to buy a problem. Let's continue. In the contract between us, you must make sure that I warrant to you that the goods, in this case the goods are books, are sold to you free of encumbrance. Why? Because you don't want to pay £30,000, it's a lot of money, and then find there is some problem with the books because some third party has a legal right attached to those books. The phrase free of encumbrance appears in most commercial contracts. Free of means without. Encumbrance means a third party right, which may mean I don't have the books to send them to you, or I have those books, but it may be a financial risk for you to buy them. So, to go back to the contract to buy books, you are the buyer. You do not know this because you're in your country. You do not know this, but I don't own the storage space where I keep my books before selling them to bookstores like yours. I actually rent a storage unit on an industrial park on the very outskirts of Cambridge, and I pay rent to a man named Mr. Robinson to keep them there. Big boxes of books like this. I can't keep them at home. I can't keep them in the city centre. It's too expensive. So I rent this awful, depressing storage unit on the outskirts of town, and I have to pay rent to Mr. Robinson. However, if I don't pay that monthly rent on time, my contract with Mr. Robinson says that he has an automatic lien on any of my property in his possession. A lien is his legal right to keep my property until I pay him, and a lien is one type of encumbrance. So look at the situation. You're going to pay me £30,000. You don't know this, but the books that you're paying for are not in my possession. Mr. Robinson has them. And if I don't pay that rent on time, he has a lien, Lien, and a lien is one type of encumbrance. In this example, the third party who has a legal right in these books, the third party is Mr. Robinson. Why third party? We say third party because Mr. Robinson is not one of the two parties to the contract for the sale of these books. Those two parties are you and I, and Mr. Robinson is the third party. That's why we say third party in these situations. Regardless, he's not involved in the contract between you and I, but regardless, he has a legal right that could prevent me from delivering these books to you on time or even at all. Mr. Robinson has legal possession of the goods you are going to pay £30,000 for. This is important. You're paying that £30,000 to me, not to him, and I don't have your books. That's the importance of an encumbrance and making sure that there isn't one when you sign that contract. How do you kill this type of risk in a contract for the sale of the books, or a contract for the sale of anything actually? Shares, hats, CDs, that's a very old-fashioned thing. I'm showing my age. Don't have CDs anymore. Anyway, if you were buying CDs from someone for some retro event, make sure there's no encumbrance attached to them. No, Mr. Robinson. You make sure to kill this type of risk that the contract states that the goods are sold free of encumbrance, including any lien. A lien is just one type of encumbrance. There are many others. So, looks like we're going to have lots of future exciting contract law episodes together to look at the other types. Pledge, mortgage, easement. We'll explain them all, but not today. Congratulations! You can now use the words encumbrance like a true legal professional. To practice these words and more, please download that free PDF, do your homework, it's vocabulary exercises. I use them in the classroom in Cambridge and I make people pay a lot of money for that, and it's all yours for free. The link is in the description. See you in the next one.